Okay, well, good morning, everyone, and welcome to this session 11 of the examination hearings. This is concerned with development management policies in the borough local plan. Just a few housekeeping matters. Should the fire alarm sound, please exit via the staircase you came up, or there's another staircase in the room beyond the head of the staircase. I'd ask any mobile phones are switched to silent or turned off whilst we're in session. The proceedings are being broadcast by webcam. The camera is up in the corner above the door. And it's important for the webcam broadcast and for people at the back of the room that you use the microphones. And I've explained before that although my microphone can stay on, only one other microphone can be on at one time. So please switch it off when you start to speak. Speak into the microphone and turn it off when you've finished. And ensure the red light is on while you're speaking. Okay, we'll go through the introductions, and I've just got a few opening remarks before we get into the discussion. So I'll start with the council again.
Good morning. Rob Jarman, Head of Planning and Development at Maidstone Borough Council.
Tony Fullwood, Chartered Town Planner, acting on behalf of Maidstone Borough Council.
James Bailey, Development Manager, Maidstone Borough Council.
Mark Edgerton, Planning Policy Manager, Maidstone Borough Council.
Megan Thomas, Barrister for Maidstone Borough Council.
Chris Hawkins, DHA Planning.
Dr Rebecca Driver, here for Headcorn Parish Council.
Cheryl Taylor-Maggio, here for Langley Parish Council.
Peter Cooling, Maidstone Calc, and part of the coordinating team.
Paul Buckley, Campaign for Protection of Rural England, Kent Branch.
Okay. Mr. Cooling, you're listed as on the participation list as in relation to Boxley Parish Council comments. Are you also representing Downswood and Ottham Parish Councils? They're part of your group?
They are part of the Maidstone Calc.
Yeah. I mean, they made a number of the representations which are referred to in the agenda.
Excuse me?
They made a number of the representations
yes,
which are referred to in the agenda.
They're part of the membership.
Yeah. Okay. On the participation list, the agenda was split into two sessions separately for the overall policies for the Maidstone Borough and those for the countryside. But as the numbers have reduced since those who originally asked to appear, I'm intending to merge those. And in any case, many of the same people who are here would be being under both sessions anyway, so we won't treat them as separate sessions. Now, the development management policies are mainly non-strategic policies, but the Council has previously proposed some changes which would include transferring some strategic elements of some of the policies to a separate strategy chapter, and also proposed that policy DM3 be split into separate policies for natural environment and the historic environment, as was discussed at session 4. There's been quite a long list of requested changes to development management policies. Some of these were considered at yesterday's sessions with some of the same participants wearing different hats. So we'll bear that in mind when we get to those points. I just want to emphasise some overall points, though, that the requested changes should relate to matters which were raised by the participants in their Regulation 19 representations. And also, I can only recommend a modification that is needed because the plan would be unsound without that modification. So to recap on the unsoundness tests and where they may be relevant, there are, I think people are aware, there are 4 tests set out in national policy, which were also referred to in the consultation, and that the plan be positively prepared, justified, effective and consistent with national policy. But the qualifications under each of those headings, because the national policy describes what is meant by those terms, and in relation particularly to the tests of positively prepared and justified, I think it's clear in the national policy that they mainly relate to strategic matters. Positively prepared, the plan to be prepared based on a strategy which seeks to meet objectively assessed development and infrastructure requirements, including unmet requirements enabling authorities where reasonable to do so and consistent with achieving sustainable development. And justified, the plan should be the most appropriate strategy when considered against reasonable alternatives based on proportionate evidence. And I think they're of limited relevance to many of the matters which have been raised in relation to the development management policies. The other two tests, whether the plan will be effective and consistent with national policy. In terms of effectiveness, the requirement is the plan should be deliverable over its period and based on effective joint working on cross-boundary strategic priorities. Now, I think that can encompass how effective a policy in the plan will be to deliver the plan's own objectives and the development which is proposed in the plan itself, or whether they'll set out to do what they seek to achieve. And consistently with national policy, I think that the first issue there is whether the plan as it is now is inconsistent with national policy, in which case there may be a case of unsoundness. So you need to consider whether is there an inconsistency between the policy as it's now worded and national policy, and then see whether a change might be needed to address that. And of course the change itself would then need to be consistent with national policy. Okay. Just one other thing, a number of changes were sought by the Kent Downs AOMB unit. They've submitted written statements for this session, but they've chosen not to appear to participate today. So when we get to their parts of the agenda, we'll be dealing with their presentations in writing, and there won't be spending much time on discussing those. Some of them are withdrawn in any case. Okay, so we'll start with the question 11.1 on the agenda. We're just essentially seeking that some expansion of the visual representations in written form, because there were some cases in which it hadn't been identified why the policy was needed for the plan to be sound, and clarify whether what was being sought was the policy to be deleted or altered, and any specific wording change the wording or text was being sought. But we'll come to those, I think, as we get to each policy. So there wasn't a general matter to raise there. Yes, Mr. Cooling.
Thank you. Your briefing on soundness is well respected. My suspicion is that my colleagues may disagree, that of the policies we're going to discuss today, there are very few, if any, as currently drafted, which would render the plan unsound. But my colleagues may think of a very few. But so we could end up with an extremely short day. But having said that, I would have hoped that instead of the borough saying, oh, the plan is sound, the plan is sound, the plan is sound, we don't need to hear about these changes, I would hope that the borough would listen to the suggestions and perhaps seek ways to have minor changes to the policies so that the plan is improved. So we will probably fail on most of our comments to demonstrate a lack of soundness. But if the borough is going to be, I don't know what word to use, but above any discussion of improvement through minor changes, then we could end up going home, all of us, and have a nice short day pretty darn soon.
Well, I hear what you say. Just to clarify, the basis for examinations is that the council should submit a plan that it believes to be sound, and it isn't my purpose to try and improve it. Unless this was a change in the way that local plans are dealt with from the previous kind of regime, and it's been in place for some time now, the new one. But under the old system, every single objection was considered and debated, and very, very long inquiries, and everything was reported on. But I think the process became unmanageable essentially, and which is why the government of the day changes, and the present government, I think, takes a similar view. Although I noticed that the size and the detail of plans has been creeping up again since then, which is why you can get into these debates about what may be relatively detailed and minor matters. But anyways, we'll press ahead. And I mean, there are some points today where the council has already acknowledged that a change would be appropriate, and we'll deal with the policies as we come to them. Okay, so we'll start at the beginning with policy DM1. Let's go it's principles of good design. Okay. Right. There's a reference in the text. I've spoken about some representations which were made by Downswood and Otham parish councils, but this concerns the debate about an integrated transport strategy, and I don't think it's of I mean, there's a wider issue there, which I don't think is of particular relevance to this policy. Just as an update, there's although we know that the council and the county council did not agree the original draft strategy to 2031, the borough council has on its own adopted a strategy since in September. So there is a strategy there, but it doesn't have the agreements that was proposed. Now, the Headcorn Parish Council also raised a matter about this policy, and it relates to the relationship of the local plan to neighbourhood plans. And the Headcorn has sought a change to this policy, so it would read, instead of reading as at present, the first paragraph at the moment reads: proposals which would create high quality design and meet the following criteria will be permitted. And the change that's being sought is that proposals will be permitted which would create high-quality design in accordance with policies in the relevant neighbourhood plan, or where such policies are either silent or missing, meet the following criteria. So I think it's essentially saying that if there is a neighbourhood plan, the neighbourhood plan has a design policy, and the proposal meets the neighbourhood plan design policy, then it wouldn't need to. I'm sure, would it need to meet any of the criteria, or only those criteria which were different to the neighbourhood plan? Because there's a long list of 14 different criteria, quite wide-ranging. I mean, unless the neighbourhood plan covers all those areas, would areas which the neighbourhood plan did not cover still rely on the local plan?
My guess is that where there were areas that the neighbourhood plan didn't cover. If it was felt that they were relevant and important, then clearly it's important to consider. I should say that in many ways the preferred option for dealing with this conflict between the current sort of proposed local plan and the localism agenda would be to introduce a sort of single policy which we set out in paragraph 5 of Headcorn Parish Council's response, which is to have a strategic policy on neighbourhood plans that simply states where a planning application conflicts with a neighbourhood plan that has been brought into force, planning permission should not normally be granted. That wording is taken out of the NPPF, but deals with the potential conflict that arises because of timing issues. It also makes it clear, which is, I think, currently missing from certainly the dialogue that Maidstone's been having, that actually neighbourhood plans are important. They're an important part of planning policy. They're an important part of the government's sort of localism agenda, and therefore having a strategic policy of this nature would help to bridge that gap. Certainly in the case, I mean, I can't comment on the design policies associated with other neighbourhood plans, but I know at Headcorn's neighbourhood plan examination, Mr. Fullwood actually praised our design policy. So he felt that that was an excellent policy, or words to that effect. So it is certainly the case that neighbourhood plans have the capability of designing or putting together good design policies. But as I say, I think the broader point is that actually there is a conflict and it could be managed relatively easily by a single additional policy.
Ms. Forward.
So I think neighbourhood plan, when made, will be, and it's not obviously for everywhere within the borough that's happening, will be part of the development plan in any event, and it's not necessary to have a policy that says it's part of the development plan. It'd be rather like saying, you know, you also need to look at the Conservation Area and Listed Buildings Act or Tree Preservation Order regulations, or something which is in operation in any event. And so I think that's the way that it will be dealt with. Clearly the Borough Council will have to use the neighbourhood plan when made as part of determining planning applications. And I don't see really any other way around that. In many cases, there will be two sets of policies.
I mean, the policy as it's set out says proposals which would create high-quality design will be permitted. Those which meet the following criteria will be permitted. High-quality design is one of those things that it's pretty meaningless unless it's by reference to some other criteria. You've got this long series. I'm just trying to see if there are any examples of here of where there could be potential for a kind of conflict. I mean, most of these things are fairly kind of motherhood and apple pie sort of provisions. And do you, I mean, Josh Driver, do you have an example of where the outcome will be different because the Headcorn design policy from anything in this policy as it's set? Yeah, I mean, it's very wide range. I understand that's difficult to do.
Sorry, if I could come back on one point vis-à-vis having a strategic policy on neighbourhood plans. It might be the case in some ways, it feels redundant, but actually because of the way development plans for an area develop, it is important because it's the latest, the most recent addition that takes primacy in the event of
Yes.
conflict. And therefore, you have neighbourhood plans that sort of either have been or are in the process of being made that are likely to be made before Maidstone's development plan. And therefore, you have the potential to say, right then, well, we just use the local plan and we ignore the neighbourhood plan.
Well, you ignore it only where there's a conflict. So yes. It would have to be an example of something where the neighbourhood plan wanted something different from what the local plan wanted.
Absolutely, yeah. But to a certain extent, the policies, particularly the demand management policies within the local plan are, by their nature, they're generic. They're designed to do something for the borough as a whole, which is not specific to the neighbourhood. So where the neighbourhood has identified that that X is important for it, then you do have a conflict. And even if the Borough Council felt that it wanted to give primacy to the neighbourhood plan, a developer could come along and say, well, actually, there is a conflict here, and it has to be resolved in favour of the latest document added to the development plan, and therefore the Borough Council's hands would be tied in terms of how it applied it. So I do think that this issue is important.
But in a sense, government or Parliament has decided that's how to treat these conflicts. You know, the most recent one should be the way to do it. And what you're trying to say is you're trying to essentially get round that provision in the Act. Yeah.
I guess the issue is that Parliament probably didn't intend that neighbourhood plans that have recently been made, and let's face it, they're coming through on relatively similar timescales, should be overridden by a generic local plan, because if they're going to be overridden, then what's the point in doing a neighbourhood plan? It's a lot of time, and it's a lot of effort, it's a lot of money that has been put into neighbourhood plans for apparently no purpose whatsoever. So I kind of do feel that actually it is important.
What is the... Okay, I understand your motives. Under what soundness heading would you say that that change had to be made?
It's consistency with national policy. Sorry, and as I said, the proposed wording for my policy is actually taken from the NPPF, so this is not sort of additional wording. It just kind of emphasises the importance of neighbourhood plans.
Okay. And it's paragraph 18... Which one is it?
The wording within the NPPF is paragraph 198 of the
198.
NPPF.
So there does seem to be a conflict between that and the section 38.5 provision, or there could be. If you've got, so you have a neighbourhood plan. Well, it does say not normally be granted. You have a neighbourhood plan which says one thing, such an area of land should be kept open, for example. Then you have a plan application to develop on that land. So 198 would suggest that the planning application should be refused because of that conflict. The local plan may have come up with a different policy which is relevant to that site, which would support its development. And if it's been adopted, depending on which is adopted later, the local plan may, by provision of statute rather than policy, need to be resolved in favour of the local plan. Ms. Forward.
So this seems to be referring to a neighbourhood development order. Is that the right paragraph?
No, it's applications and
198, was it?
where a plan application conflicts neighbourhood plan. Let's have a look. Maybe it doesn't work, please.
Okay.
Yes, because a neighbourhood development order, you wouldn't need
Yes.
planning application.
Okay.
So, but this is where a plan application conflicts with the plan. It's important to force. Planning permission shall not normally be granted. It's under the overall heading of determining applications, so I think it
Yes.
applies in that case.
But as I think you said earlier, you can't use a local plan policy to override sort of national legislation.
Mm-hmm. Well, I suppose what Dr. I was saying is if you write that policy into local plan, then by definition it can at least be argued then that there isn't a conflict with the local plan. I suppose there isn't a conflict between the plans. But there might be conflict between policies in the plans, other policies in the plans. But you'd have it's an arguable case that there isn't a conflict with the plan as a whole. It's a rather tricky situation, I think. Yes.
Sorry, can I give you an example in the context of policy DM1 where there might be conflicts? One of the things that came out of Headcorn's neighbourhood plan was the importance of retaining the feel of being a country village. That was one of the driving forces underpinning the neighbourhood plan and a clear part of our shared vision, which the examiner stated he'd never seen such a strong shared vision ever in terms of kind of how that played out. Part E of our HMP1 policy on design policies for Headcorn is that it ensures that any new roads visually resemble country lanes and traditional village streets in keeping with the existing streetscape, for example, through the use and retention of matured native trees and hedgerows lining the road, appropriate choice of scale, width and layout, and sensitive choice of the way in which new buildings relate to the road. Now, in terms of design policy DM1, that type of kind of retaining the feel of being a country road would not be retained. One of the reasons that we kind of put that within the policy is because recent developments have had streetscapes that basically they involve vast areas of concrete. They're completely at odds with the surrounding streetscapes. They're clearly consistent with the design policies put in place by Maidstone and possibly, presumably, Highways England as well, but they're not what the residents of Headcorn Parish are looking to achieve. So there are subtle differences in terms of interpretation, and I think that recognising those differences is important.
What about if instead of doing what you suggest, if you add another criterion onto the list of criteria in DM1, which would be to the effect that it also something like just referring to additional design criteria set out in neighbourhood plans. Ms. Forward.
I wonder if I can help in the sense that over the page, at page 204, there is already a reference, and we're coming onto this in many cases now, but account should be taken of conservation area appraisals, Kent Design Guide and so forth, but whether neighbourhood plans is added to that list. I mean, just for the avoidance of doubt, really, because I think they would be in any event.
Let's try. How about that?
I guess it would be better than nothing, but it's not as good as making sure that, because account will be taken, it doesn't mean that actually the most important thing when deciding on design policies for a neighbourhood area is the design policies within the neighbourhood plan. Mm-hmm. And it's that sort of primacy that is envisaged within the localism agenda running throughout the NPPF. It's very clear that neighbourhood plans are designed to be a powerful tool to allow local communities to influence the type of development that they get. And having it as a sort of one of several things that you need to think about doesn't give it that sort of primacy.
Yeah. I mean, as part of the development plan, it's going to have a different status to the other documents in that list.
Because it is part of the development plan,
yes.
And we have to, by law, give careful consideration to any neighbourhood plan.
But yes, I mean,
Sorry, the issue is where there are conflicts and how those conflicts get resolved.
I've looked at requiring good design in the NPPF, but you haven't identified where there's potential conflict between DM1 and the NPPF.
The conflict arises because of the conflict with the localism agenda and the neighbourhood planning agenda within the NPPF, which clearly... it's got to do with DM1 because if you have a situation where the NPPF sets out that local communities through neighbourhood plans should be allowed to shape development and get the right type of development for their local communities, then if conflicts are being resolved in favour of a generic policy rather than the neighbourhood plan policy, that clearly goes against the intentions of the NPPF.
I'm struggling to understand the specific concerns, but Roman numeral 1, criterion 1, states, create designs and layouts that are accessible to all. So that's meant to be inclusive.
But I think well, the point you make is about character, wasn't it? Is design character of
The point that I'm making is not a specific criticism of the design criteria within policy DM1. It's about the fact that actually, in sometimes subtle ways, they differ from the priorities put forward in the design policy within Headcorn's neighbourhood plan. Now, the point of the neighbourhood plan, of any neighbourhood plan, is that it should be shaping development. And if those conflicts are going to be resolved in favour of a generic policy, then actually there is no point for doing a neighbourhood plan, particularly in a situation where you've got a borough council who is seeking to make every single allocation strategic, even down to housing allocations of 5 houses, which are equivalent to 0.03% of Maidstone's objectively assessed housing need. So it's about making sure that there is a role for neighbourhood plans within Maidstone Borough.
What if the additional criterion said, you start off as it is now, proposals which would create high quality design and meet the following criteria would be permitted. You have your list of criteria there, and the extra criterion has something to the effect of just additional design criteria in made neighbourhood plans. So that where it's something, so if you talk about additional matters, then it isn't it's cases where there isn't say a conflict necessarily, because I mean most of these things, I say, you needn't disagree with I think with the other criteria as they're set out here. You haven't got any specific objections to those criteria as set out. But if there's something extra that you want to talk about, such as this road design reflecting ridge character or whatever it is, that's an additional thing to be taken into account as well as these other ones.
I guess, again, that might help, but, I mean, you can see the reaction from the idea that actually neighbourhood plans play an important role in shaping development. Kind of my fear is that, the neighbourhood plan stuff gets dropped off the bottom, and actually it's kind of where there are conflicts or where the neighbourhood plan would deliver a different outcome to the main criteria within policy DM1, you end up with the DM1 policy, which is a generic policy not designed for the neighbourhood. So again, I feel that a policy that actually made it clear that where there were conflicts, that the neighbourhood plan should be the one that prevails, is actually important.
Okay. Ms. Cooling.
Thank you very much. This is such an important subject, and I fully support what my colleague has been saying. There's history here. About 15 or 20 years ago, in the deep and distant past, there was a document called a Village Design Statement that a number of villages put a lot of effort into, and the borough at the time, different people no doubt, effectively dismissed them, took no account of them whatsoever. And therefore I fully support my colleague. If these neighbourhood plans, and by the way, they're far from trivial in cost and resource, and those brave parishes who've been progressing neighbourhood plans, it has been with a heavy wind coming from the front in terms of, I'll be blunt, in terms of perceived cooperation from the borough. And therefore, yes, if neighbourhood plans are given some sort of status, they will challenge the absolute authority of the borough. But the neighbourhood plans are essential for those parishes which have taken the trouble to put them together. And therefore, I absolutely agree that the policy should somehow be modified, not to say take account of, because that is, forgive me, unless there's a willingness to take account of them, they can be totally dismissed. So the policy needs to give a mandate that where there is a neighbourhood plan, whether it's put in place before the local plan or after it, in certain situations, it should prevail, as long as it doesn't threaten the truly strategic aspects of the local plan. And as my colleague has said, strategic is being interpreted at a minute level here and there in the local plan. So please, we need to give neighbourhood plans formal status within this local plan. Okay. Thank you.
Mr. Edgerton.
I think what we're trying to do here, sir, is to deal with issues which are best dealt with at national level. The problem is we're trying to plug the gap through local policy. In doing so, there is a danger, I suppose, that we will insert something into DM1, giving some form of primacy to a neighbourhood plan or a particular part of a neighbourhood plan, which has been legitimately superseded by the local plan coming forward, or variations to the local plan coming forward. We're therefore still giving primacy to parts of a neighbourhood plan, even when they shouldn't be, if it's placed inside policy in that way. I'm not entirely convinced that trying to deal with this issue through criterion in a policy of a local plan itself is the best way forward, and this is something which should probably be dealt with at national level. Ms. Thomas.
So I think that Dr. Driver's accepted that policy DM1 is a generic policy. So at the end of the day, even if there's an adopted neighbourhood plan policy which is more specific, it shouldn't conflict with what is effectively a generic policy. And I think you've got to be careful here, because we do actually have primary legislation that says where there's conflict, a policy which has been adopted later in time than another policy obviously prevails. By that, a decision maker would give it more weight. And I think that's right, and that's primary legislation. We still do have the advice in paragraph 198 of the NPPF, which says that where a planning application conflicts with a neighbourhood plan that has been brought into force, planning permission should not normally be granted. And I think that's, it's got the normally in there, which is the most important thing. So you wouldn't normally grant it if there is that conflict. And you can still have regard to that if it's a development which Headcorn think is a development which conflicts perhaps in design terms with what they're trying to achieve. But as I say, that shouldn't really ever conflict with what is, as Mr. Jarman has called it, a very inclusive, generic policy that we've got in DM1 if you actually look at the terms of it. So I think if you give most weight to what's said in primary legislation, then advice here second. I don't think it's advisable really to start to insert in the policy references to perhaps weight that neighbourhood plan policy should be given if it's taken to be that way.
Okay. Okay, well, we've got lots of other matters to move on to, but we'll want to conclude this discussion shortly. But Dr. Driver.
Can I just say that in terms of conflict, neighbourhood plans should be in general conformity with the strategic policies of a local plan. This is not down as a strategic policy. So, in fact, if a neighbourhood plan wanted to completely contradict this policy, it would be entirely within its right.
And if it was made later, then it would be
and if it was
primacy.
made later, then that wouldn't be an issue. The issue is because you have neighbourhood plans that have already come forward within the borough, and given that within the MPPF itself, it states that it kind of paragraph 198 of the MPPF states that where planning applications conflict with the neighbourhood plan that has been brought into place, planning permission should not normally be granted. I'm not sure why I see there's a big problem with having a policy within Maidstone Borough. It's not doing anything that conflicts with national legislation. It's simply saying that actually, hey, neighbourhood plans are an important part of planning policy within the borough. It gives weight to neighbourhood plans. It should not normally. There may be situations where it might be granted, but it gives weight to the neighbourhood plans in the decision-making process that, frankly, kind of at the moment nobody seems to want to give that weight.
Okay, Mr. Cooling, one last comment.
Thank you very much. We have not had the benefit of legal opinion. And what I hear about primary legislation, I just do not understand why Dr. Driver's suggestion of putting something in, and if it is contested by a developer at some point of time in court, it would be an incredibly brave judge to actually dismiss the weight of a neighbourhood plan given the Localism Act. So we have not had legal opinion. I don't think we should be perturbed by what we've heard from the borough's advisor, and I fully support Dr. Driver's suggestion. We must somehow give some role, formal role, not a discretionary role, a formal role for the neighbourhood plans within the context of local plan strategy. Thank you.
Okay. I mean, well, the neighbourhood plans will have a formal role in that they are part of the development plan. A policy in neighbourhood plan which isn't the neighbourhood plan can have policies which are different from the local plan if they're in general conformity with the overall strategy, and design policies, as I was saying, are unlikely to be in conflict with the strategy. And if you're dealing with an application, you'd have to have regard to the neighbourhood plan, even if it predates the local plan. And it's only cases where, and I think it's going to be more about particular site allocations, designations, and things like that, rather than rather than these kind of design criteria where there's some potential for real conflict, where you have a situation where the local plan is making an allocation, the neighbourhood plan wants to protect the land for some different use. Those are the sort of areas where you're going to have conflicts.
Sorry, can I say that we've got a planning application coming through the village at the moment, which basically has based its design criteria on the Kent Design Guide rather than the criteria within the neighbourhood plan. It is clearly in conflict with the design criteria within the neighbourhood plan, but in terms of ticking the box for this policy would be fine. And that's why I have concerns. Neighbourhood plans, in particular for the design policy.
If your plan was made, then the council has to take what the plan says into account. And if there's a conflict neighbourhood plan, there has to be material consideration why you decide that other than in accordance with the neighbourhood plan.
But I guess the problem is that if the neighbourhood plan is made first and then the local plan comes into force, the local plan trumps the neighbourhood plan under legislation because of the way it's phrased in terms of the most recent addition.
But why in this design policy would the design policy doesn't require it requires account of the Kent Design Guide. It doesn't require compliance with this. And if you have a policy which says the design should be something in the local plan, if the neighbourhood plan were a made plan and the policy said something different from what the Kent Design Guide says, then the neighbourhood plan would have more weight than a design guide because it's a plan policy.
I guess my suspicion, experience is that in fact the policies within the neighbourhood plan are typically given very little weight, including the design policies. So I realise at the moment the policies in Headcorn are part of an emerging neighbourhood plan rather than an existing neighbourhood plan. But frankly, to a certain extent, given the importance of localism within the national planning policy framework, I'm not sure why it is such a big problem to actually state that where a neighbourhood plan has design policies, or indeed policies covering anything else, but specifically around design policies, given that neighbourhood plans are supposed to shape development in their area, why it is such a bad thing to have that recognised and to give them some sort of primacy within the local plan.
Okay, well, I think we're getting over the same ground now, I think, and it isn't my role to conclude whether things are bad things or not bad things. I have to follow the soundness test. So, the council has given its reasons, including, say, legal advice on this, and so I think we're going to have to move on from that and leave the matter of the relevant status of the plans to how it's set out in national policy.
Will that legal advice be taken as the advice?
No, I'll say that's what the council's opinion is given on their legal advice. I'm not saying that people could give different views, but that's. I mean, at the end of the day, the recommendations that I make to deal with soundness matters have to be things that the council actually agrees is necessary to make that change as well. Okay, right. We've got that's DM policy DM1. We've got quite a few to go. Yes. Okay. All right.
Sorry, sir. Yeah. If we're not going to do anything specific, maybe they could at least make reference to the neighbourhood plans as you previously suggested within this policy.
Well, that is a change. That's what we would.
Yeah.
So then the council doesn't agree that that's needed, and they've given reasons, and I accept the council's reasons for that. Okay. Right. So. moving on then, we have DM4, I think, next. So DM3, we did discuss at session 4. So DM4 is development on brownfield land. And this is the provision which I think was touched on actually yesterday as well, which provide, I think the specific points are essentially it supports development on brownfield land within the settlements under the first part of the policy. And then in the second part, exceptionally the residential redevelopment of brownfield sites in the countryside, which meet the above criteria, which are in close proximity to major urban area, a rural service centre or larger village, will be permitted, provided the redevelopment will also result in a significant environmental improvement and the site is or will be made demonstrably accessible by sustainable modes to major urban area, a rural service centre or a larger village. Now again, there are some several observations raised about this. I think in particular, the three matters are that the coordinating team they say support the policy as it is. Subject to additional criteria, the number of new dwellings should not be such as to overwhelm the rural service centre or larger village or the local social infrastructure. I think this matter of what overwhelms a village is a bit like this is what dominates that we were talking about yesterday. That I don't know how you define that. And are you talking there about development within or outside villages?
I think within the village context, whether it's directly inside the old envelopes or it's just outside, it's the context of the village being affected. And if words such as dominate is allowed elsewhere and it is subject to interpretation, yeah. I think we ought to give some sort of credence to overwhelm and hope the borough will interpret it favourably.
I think to use one of your favourite phrases, I think overwhelm is in the eye of the beholder, isn't it?
If it can be our eye, then we have no problem whatsoever.
I thought we might.
Or even your eye.
Okay. So look at the again, Headcorn also made representations about this. They weren't on the original agenda, but they were in their original representations. And your concern is about the development in the countryside outside villages. And you're particularly concerned about high-value economic sites in the country being converted to residential use. There is, I think, the sites you're concerned about in the Headcorn context, are they not sites which are protected for employment use by other policies? I think Barradale Farm, was one site, for example.
Barradale Farm is only one of several sites that we have scattered around Headcorn countryside, and therefore we kind of felt that change was important. We did propose some changes in paragraph 13 of our representations for this session, which are consistent with the wording of paragraph 55 of the MPPF to sort of help with consistency and therefore soundness.
I think I said at the outset, you have to start with the position of why the policy is not consistent with MPPF first before saying what does need to make it consistent. So, okay, 55. Okay, so paragraph 55 is promoting sustainable development in rural areas and where housing should be located. And you give some examples. These may relate to where it doesn't refer specifically to brownfield land. It's about where exceptionally there may be housing in the countryside.
There is a provision where development would reuse redundant or disused buildings. It should lead to an enhancement of the immediate setting. So the suggestion was that that kind of point around enhancement of the immediate setting should be added to the policy.
Well, it says significant environmental improvement at the moment, as in the policy. The development will also result in significant environmental improvement, and the site is accessible.
Sorry, I'm trying to...
In fact, that text, in your suggested wording, that text is retained, because you say would reuse, redundant, or I mean, there's another policy on reuse of buildings, because this isn't about reuse, this is really about redevelopment of brownfield sites in the countryside.
Okay.
But the policy on reuse, could you just remind me where the TM35, I think, was conversion of rural buildings. So we have one policy which sets out, which is about reusing buildings, and then and that relates to that part of NPPF 55 you referred to. This is a policy about redevelopment in the countryside.
I guess one point is this primarily looks at or is focused, the policy as worded, is focused on the rural service centres and larger villages. But actually the NPPF more generally, in paragraphs 54 and 55, don't make that distinction in terms of a rural settlement hierarchy. Indeed, paragraph 55 of the NPPF specifically allows for a situation where kind of development in one village might support services in another village. So it's actually not about concentrating development on kind of in particular communities in rural areas, and therefore having a policy that relates to rural settlements rather than specific types of rural settlements would be more consistent with...
So you're saying that you'd only need to be near a settlement of some sort, even if it doesn't have any services? Because the council is trying to set this policy up for development to be sustainably located, not isolated. And so it's trying to find sites which are accessible to places which have got some services.
I guess the issue is that all rural communities may have the need for housing, and if, for example, brownfield land is likely to fall into disuse, then simply because it's not, it hasn't been given a badge that the Maidstone Borough have developed, but which is not within the NPPF, it seems to somewhat conflict with that. Development in rural areas within the NPPF is treated pretty much equally. Indeed, the only reference to rural service centres is in connection with promoting tourism in paragraph 28 of the NPPF.
I mean, your original Regulation 19 representations were the policy should only allow brownfield developments within village boundaries. Right? Now you seem to be suggesting you should allow brownfield developments in villages which don't have services.
Sorry, so the policy wording that is being proposed is proposals for residential development on previously developed land, brownfield land, in or immediately adjacent to Maidstone's urban area or rural settlements that make effective and efficient use of land and which meet the following criteria would be permitted.
Right. So it's a change from within settlements to within or adjacent to settlements, but it's within or adjacent to any settlements, including those which don't have services.
Yeah.
Okay. I think, yeah. Well, that's departure from your original representation. So I want to concentrate on the original representation, which was to say that no development on brownfield sites outside settlement boundaries. That's what you originally were seeking. Okay.
So you did ask for specific...
Well, yeah, specific wording, but following your original representation. I mean, so specific wording will be to say only within boundaries, or delete that second paragraph of the of DM4. That would be a change to give effect to that. Okay. It isn't, as I know it's very tempting, especially when sometimes it's made original representations and you've had better ideas or new ideas since, but we need to stick to what's we just sought. Mr. Hawkins, you made representations on this policy as well.
Thank you, sir. Very briefly, the comments that we made are with regards to the requirements of the NPPF in terms of development of brownfield land. And we've raised the question as to, whilst we understand the sustainability argument of them being adjacent to or within the existing confines or adjacent to the confines, there's nothing in the NPPF to suggest that. And we're just very mindful that there are, on rare occasions, admittedly, instances where, when weighing up the three threads of sustainability, the benefits to the environment on occasion are so significant in more remote areas that they would justify an approval of planning permission. And we agree with the wording of the two criteria that are shown, and we understand that there would have to be very exceptional circumstances, but we have seen that within the borough previously. Sites up at the MOD at Thurnham, for example, sites at Detton and Stockbury, which have all been approved with parish council support, actually, it's my understanding, but they wouldn't meet the criteria of this policy as set out. So it's just to try and encourage some flexibility within the wording that if there are these, I think, rare instances, they wouldn't then be set out as departures from the development plan, but could be permitted as a result. Thank you.
Sorry, did you say you suggested some a particular
wording? Within our...
Yes, I've got it here, yes.
Yeah. To be honest, actually, in hindsight, I wonder whether we've gone a little far. And I think, I think it does still need to be exceptionally, and I think that wording makes sense. But whether actually the criteria that are shown are sufficient to give that security without the wording for proximity to existing service centres, because I think the NPPF is inherent in terms of it runs through in terms of sustainability. So it will be only in those exceptional circumstances that the sites are able to come forward, but we think there will be occasions when that is so.
It's just, I was not clear how you define the exceptional circumstances. I mean the original modification you suggested essentially just adds in the countryside to the first criterion. It's the same criterion will apply whether you're inside a settlement or outside a settlement on that criteria. If the only thing, the only two things which are different in the countryside are, one, you have to show the significant environmental improvements, and the other is that this you have to show proximity to one of these designated settlements and demonstrably accessible by a sustainable mode. So which of those is you think you don't need? Which of those? You're still saying the significant environmental improvement. Is that still?
Yeah, we think there needs to be a significant environmental improvement. I think that's accepted because I think that would be the weighting that you would give when judged against the three tests. Like I say, there are sites that we're aware of that wouldn't meet the other criteria, but certainly have been granted planning permission in the past for very sound reasons.
And presumably they didn't meet the criteria in the past either, and were allowed as exceptions. The council always, if it's a good enough case, the council has always got the option of setting the policy aside and say, if this policy is not very specific about what it means by proximity, then that's a bit of flexibility in itself. as opposed to the kind of immediately adjacent to the suggestion. But I mean, if significant environmental improvement is the only criterion, then there would be no sustainability. I mean, it could be very remote. Well, I'd say it isn't such a huge district to be that remote, but it could be entirely reliant on travel by car and maybe potentially, depending on the site, different numbers of dwellings or movements. But let's forward.
So if we take case law as being brownfield sites are garden land in the countryside, without that sustainability criterion, then it's open season in the countryside for residential development. I think we can take our lead from it's paragraph 30 in the NPPF, which talks about encouragement should be given to solutions which support reductions in greenhouse gas emissions and reduce congestion. In preparing local plans, which is what we're doing obviously, local planning authorities should therefore support a pattern of development which, where reasonable to do so, facilitates the use of sustainable modes of transport. And that is exactly what this policy is aiming to do in the countryside.
Okay. Just on that point, you mentioned about the gardens. I mean, it doesn't seem to me that the policy has to just use the definition, the legal definition of brownfield development. You could say you could specifically exclude gardens if you wanted to, gardens in the countryside.
Yes, you could, and we've had many a discussion on this policy, but I think we firmly believe, and I think Mr. Hawkins is saying this as well, there's one of the main strands of the NPPF is a sustainability strand. And we're very conscious that previously developed land can apply to lots of things. It doesn't apply to just land which is occupied now. It applies to land which was occupied. But we're very conscious that there are many of these sites in the countryside, for example, equestrian development, a few horse shelters in the AUNB, for example. I would say in an unsustainable location does classify as a brownfield site. And arguably, a bit of an extreme example, it could be put forward that building one detached house, single story, is environmentally better than the horse shelters that used to be there. However, we want there to be a strand relating to sustainability. Mm-hmm. I understand where Mr. Hawkins is coming from, but another extreme example would be what I call an old-fashioned term, a bad neighbour use. Mm-hmm. There might be a builder's yard that started off in the 1950s, it's got a CLD, it can operate 24/7. Now and again it causes problems for the neighbours. With a planning application, in terms of other material considerations, we would take into account, the site specifics and the history. But for this policy in the local plan, we think there should be a main strand relating to sustainability in terms of location.
So has the council relaxed about the redevelopment of gardens in the countryside? I mean, I'm thinking about, I'm thinking of the recent case I dealt with in which a curtilage had been expanded to take, to become quite a large field, and then it was argued that the whole site's brownfield.
No, we're not relaxed about it, and again, it's so wide-ranging. Most of the time, the gardens in the countryside tend to be larger and they tend to be open, so the sort of environmental benefit, if you like, of building a house would be harder to prove. However, given the sort of the recent case law, I think the Dartford decision's been challenged, isn't it, in the High Court. Okay. We'd be happy for a specific reference to residential gardens.
Mm-hmm. So, the change in that case would be in item 2. So it's actually residential development of brownfield sites and countryside, which are not residential gardens or something like that, or it doesn't. It covers you whatever the outcome of the court case. Then you're avoiding that. Ms. Cooling.
May we have clarification somewhere or other that brownfield does not include land that has previously had solar panels, polytunnels, or turbines on them. And we heard from a very senior civil servant from the relevant department that certainly solar panels do not end up turning a land into a brownfield. So could we please have explicit reference to that? This is not a soundness issue, but it's clarity. Thank you.
If you don't mind, Mr. Mellor, we can have a discussion afterwards, but the first sentence in the NPPF glossary, previously developed land which is or was occupied by a permanent structure. So then there's an argument about whether or not the solar panels it's the same.
Usually, they're usually temporary permissions. So.
Yeah.
And similarly with the turbines,
and our practice is to grant temporary permission.
That is categorically not the case for polytunnels. Solar panel applications tend to have 20 to 30 years.
Polytunnels are agricultural, aren't they? Agricultural buildings are excluded. Yeah, but I think they qualify as agricultural buildings and agricultural buildings that don't qualify as brownfield.
Okay. In that case, and I will put the microphone on this time, for solar panels, the applications that we've seen are not for a few years. They're not temporary. If you think that 20 years is temporary, so be it.
Well, it's temporary. It's not short term, but it's temporary.
So is there any problem with having some clarification somewhere so that the next generation of planners actually stand by and recognise that solar panels and turbines do not give, and industrial level polytunnels do not give some sort of brownfield precedent?
I think you have to rely on the legal and policy definitions for that nationally rather than trying to change them here. I mean, yeah, okay.
We haven't had the benefit of legal advice. Maybe the borough has. Again, if there's some clarification that would not be illegal, why don't we have the clarification for the benefit of those who read the local plan? And it is not just professional planners who read the local plan.
Yeah, okay. We're delving into new areas that you didn't make representations on, so I'm afraid so. Okay. Can you put the microphone on, please?
Sorry. Just regarding the Dartford case, that's all I wanted to talk about. I spoke on Monday with the case officer at Dartford Borough Council, and he advised me that they're going to the Court of Appeal on either the 8th or the 9th of March. Those dates have been penciled in for that hearing.
Okay.
So at the moment, I think it's watch this space.
Yeah, okay. I think that just so it's kind of belt and brace thing. If you make that change to exclude residential gardens anyway, then it doesn't matter what the outcome of the case is. Okay. Right. Where are we up to? Yeah, that was the question 11.5, wasn't it? So I dealt with that. Okay. DM5 air quality. Let's have a look. Right. put in this question 11.6. There's two aspects of this. There's the representations made which are seeking that no development should be permitted which may exacerbate an air quality situation until mitigation measures of this issue are implemented. And there's another series of questions here as well. Who would undertake mitigation? Would make the policy be effective? So I'll take all these 11.6 to 11.8 together, because we've got some lengthy submissions in response. The first is the Council is proposing a change to the policy wording, saying they see value in clear, consistent policy wording. Right. So at the moment where it says, I think, let's get the actual Council response. I think the Council schedule, it didn't follow the usual convention about showing how the policy wording has changed, and I've kind of derived mine by comparing the original wording with the new wording shown on the schedule. So if I've got this right, I think under criterion 1, I'll read out what the policy says at the moment. Air quality. Proposals that have an impact on air quality that meet the following criteria will be permitted. Right, so at the moment, criterion 1 says proposals located close to identified air quality exceedance areas as defined through the local air quality management process will require a full air quality impact assessment in line with national and local guidance. And that's supposed to be changed to proposals located within or adjacent to and potentially have a negative impact on identified air quality exceedance areas as defined through the etc. So that's essentially amending from close to adjacent to and potentially have a negative impact on. Okay. Yeah, that's the only change, I think, is it? In the okay. Right. I mean, one of my original questions, I think, it was because they use different terms in each of the three criteria. So that first criteria was proposals located close to, and that will become within or adjacent to. So that's the same then for these air quality exceedance areas as it is in criterion 2 for air quality management areas. Then criterion 3 is proposals in or affecting air quality management areas. And I'm a bit close to, I was a bit puzzled about why the different terms are used in each of the criteria. So you've married up the two criteria in criterion 1 and 2, so they both become within or adjacent to. And then the third one is in or affecting.
Could be downwind.
Well, I understand that. I'm just trying to understand the reason why there are different criteria, different wording in each of the criteria. Well, perhaps as you explain, what are the different, in criterion 2 and 3, what are the different objectives of those two criteria? they both refer to mitigation. 2 specifically talks about identifying the sources of emissions and providing emission statements.
Excuse me, butting in. It does look as if number 3 could be deleted, but that...
Well, I'm wondering if they can be merged or something. Just to, yes. I mean, does there need to be a way to assess the scale of proposals? There needs to be a way to assess when you need an emission statement and when you don't. And when you need mitigation measures. And you haven't actually got a mitigation criteria in relation to the air quality exceedance areas. Can you just explain the difference between the air quality exceedance areas and the air quality management areas?
Yes, sir. There are 6 air quality exceedance areas in the town, in and around Maidstone town. But the Borough Council declared the whole of Maidstone town as an air quality management area. So it's a very much wider location. Yeah. I have maps of the exceedance zones, and these are really I suppose these are really the hot spots. There is a sort of fairly blanket coverage and much less precise, therefore. And there are certain areas within the air quality management zone which are not in exceedance, most of them. So the real hotspots and the real tests, the highest tests should be for the exceedance areas, the 6 areas.
Okay. Right. So starting from the kind of lowest level, you'd have a proposed development in Maidstone within the air quality management area, but not in an air exceedance area, and depending upon its scale, you may or may not require a scale and likely impact. You may or may not require an emissions statement, and that may not lead to requirements of mitigation. So it's a very small scale thing. Someone putting up a garden shed, it's a small development. There's no issue with air quality. So you don't go and ask them for an emission statement. You don't seek any mitigation. And then you build up to the stages until you get to the point where you're dealing with larger developments, generating traffic or industrial emissions or something like that. When you do seek an emission statement, and that, I mean, what's the difference between, you've got the air quality impact assessment and you've got an emission statement. So the emission statement is just identifying, well, so again, what's the difference between those two? The emission statement is a lesser thing than the air quality impact assessment? Or, yes. Okay. So if you're not within or near an air quality exceedance areas, you just need emission statements. And then we get to developments which are going to affect the air quality exceedance areas. Now, it says, so you worked up, you started, so you kind of small developments in the AQAMA, but no effect. Larger developments within the AQAMA, which do have an effect. And then developments on the amended wording within or adjacent to and potentially having negative effects on the air quality exceedance areas. And then the next step up. And then you have an air quality impact assessment. Now, is mitigation already included in the air quality impact assessment? Is that part of it? Or because as written here, well, I suppose if the air exceedance areas are all within the air quality management area, then the air quality management area provisions apply as well.
Yes, we would expect mitigation to be part and parcel of the air quality mitigation. Air quality impact assessment. Sorry, just to draw your attention, sir, to paragraph 17.41 of the explanatory text, where we say the low emission strategy will outline the principles behind defining the scale of the development and its likely impact depending on its location and proximity to exceedance areas and the public.
I mean, could you have developments which are some distance from air quality exceedance areas that could still potentially affect them? I mean,
yes, definitely. As Mr. Coolin referred to, downwind, particularly in a valley, and we do have valleys in Masonborough.
But also thinking about traffic impacts. The traffic impacts can be some distance from the developments and going through the air quality exceedance area. So I mean, again, close to still may not be the right definition. I mean, what I'm concerned about is development potentially affecting.
Yes, affecting. Yeah, as in criterion 3.
It just seems that it isn't. I don't know, very clear or coherent as set out at the moment that. How you progress, where you progress from one stage to the next, or where you do and do not require an emission statement or an air quality impact assessment. Yeah,
would it merit splitting it into two, with one part dealing with the exceedance areas, and the other part the rest?
Yeah.
And within the exceedance areas, yesterday we touched on the words mitigate and minimised. Perhaps for the exceedance areas, there should be maybe absolute words such as fully mitigate. Whereas for the rest of the air quality management area, the whole of the borough we've heard, the words that are here at the moment may be usable. So split in terms of severity of the current situation.
Yes.
So as you probably note from looking at our representations, our view has changed quite radically over the years. And we are very concerned regarding air quality. I'm concerned that this plan, here we go to the NPPF paragraph 124, it says planning policy should sustain compliance with and contribute towards EU limit values or national objectives for pollutants, taking into account the presence of AQMAs. And that phrase there, should sustain compliance with and contribute towards, is quite pertinent. As you may be aware, sir, there was a recent High Court ruling from Mr. Justice Garnham. Yep. That was published on the 2nd of this month. It was between Client Earth, the Secretary of State for the Environment, Food and Rural Affairs, Mayor of London, Scottish Ministers, Welsh Ministers and Secretary of State for Transport. Mr. Justice Garnham, in his conclusion, and this was looking at the government's air quality plan, which the judge found inadequate, and in conclusion on paragraph 95, bullet 1, it says that the proper construction of Article 23 of the European Guidance means that the Secretary of State must aim to achieve compliance by the soonest possible date, that she must choose a route to that objective which reduces exposure as quickly as possible, and that she must take steps which mean meeting the value limits is not just possible, but likely. The policy as written and as put forward in the Council statement in 2, it talks about, in that last 2 lines, identify how these emissions will be minimised and mitigated against must be provided. Minimised and mitigated against may not result in a reduction of air quality in the AQMA or elsewhere in the borough that would meet the Article 23 and the EU requirements. And that is a real concern, sir, that policy will not necessarily achieve that objective, which is set out in the NPPF, and therefore, from a soundness point of view, is unsound on that criteria.
So on which soundness criteria?
Not compliant with the NPPF, or not consistent with the NPPF. Because the NPPF should sustain compliance with and contribute towards. And it's questionable.
But doesn't that depend upon what the what the emissions are and what the mitigation is in each case? I mean,
that's right.
If the policy says, minimise and mitigate, it's actually how you interpret that rather than what the policy says.
Maybe, but we don't know that there are 6 exceedance areas within the town centre AQA. And the question is, how is new development, traffic, going to affect that? One of the criticisms of the government's plan was that it used assumptions regarding particularly diesel engines, that their compliance was not as great as what was assumed, and therefore, again, it comes back to the information the Council has through its air quality studies as to what assumptions have been made about the future. But again, we come back to seeking to have compliance and reverse areas that are of high air quality. And there are 6 in the borough. Mm-hmm. How are they going to be affected, and how is the Council going to reduce that exceedance to within legal limits? Those are my questions there, sir.
Mr. Jarman.
Yes. I understand the sentiment, but at the end of the day, if, say, 100 houses were being proposed in an exceedance area, one of the main ways that the planning process can intervene and reduce nitrogen dioxide levels is to provide better quality public transport, sustainable transport. But it would be unreasonable to request one housing company to solve all the problems of one particular air exceedance area. There must be some proportionality in this.
I mean, yes. I mean, there's an existing issue. Obviously, we've got an existing air quality problem identified here, and that, I mean, the government's going to need to respond on these legal cases, and it has to come up with a new strategy, And there are things in the government's control which are not in the borough council's control, such as fiscal measures to get people to shift, to use different means of propulsion, electric cars, whatever it is, and those kind of things. There's also matters that in relation to transport for the highway authority, things they could do independent of what development goes on. When the borough council, they have to deal with the situation regarding each of the, each development as it comes forward. And this is a policy which would apply to either whether it's windfall developments or allocations in the plan when the applications come forward. Then they, if there's an air quality issue, then it needs to be dealt with through this process. And then how much. How you, once having assessed the impact, how you minimise and mitigate that is going to be a matter that you have to deal with on a case-by-case basis, unless until there's some national policy, and that's what this policy is seeking to do. Mr. Chairman.
Yeah, thank you for that. And obviously on a borough-wide level, one of the main reasons why we have brought out an integrated transport strategy is to improve air quality.
Mm-hmm. Yeah. Because obviously we have a strategy. We've heard obviously when we discussed rural service centres, with Dr. Driver was articulately talking about how people commute to work. We have 3 villages, Marden, Staplehurst and Headcorn, which have rail, but the rail takes them east-west, doesn't link them to Maidstone. I'm not sure that the public transport is that good. If it's as good as it is to Lenham, it's 1 an hour. Lenham is a growth area, 1,500 homes more. To encourage people out of their car, come back to those 3 villages, the main roads from them to Maidstone take you through the Wheatsheaf pub junction of the Luce Road and Sutton Road, which in the current evidence the council has for air quality is at exceedance, is at trouble, is in danger. Mm-hmm. So you are having a lot of potential further vehicle movements into the town and then on into the town centre, AQMA, that could well make things worse. To improve people's use of buses, you have to have what I call a walk-on service, at least every 15 minutes, because that encourages people to know that when they get to the bus stop, you'll catch a bus. And it will be there, rather than having to wait now because I just missed it. And also, it would have to be regular, from early-ish morning to get people into town because of the time it takes to get into Maidstone, and late at night if they wish to use the facilities in the town centre. So I'm not against the concept of improving bus transport. Mm-hmm. It's just that I'm not sure that is necessarily a practical mitigation problem issue. You may have other sites. We have Woodcut Farm, for example.
Yeah, but I know we've debated these matters at other cases already about the location and the spatial strategy. We're not dealing with that here. We're dealing with an application with a policy which is concerned with what you do when you have an application, wherever it is, whether it's in the and we can't have the debate about where you cite development as part of it.
What I was trying to get through, sir, is that we talk about mitigation. Mm-hmm. It's whether that mitigation will end up and be able to meet the requirements of MPPF 124 in sustaining compliance with, particularly where there is over the air quality exceeds that guidance.
So, for example, you say bus and so on. For example, mitigation might be park and ride service, which would help to deal with that particular problem you've raised about people coming in from the villages and then getting sent through this. If there's a park and ride service, then that is a kind of mitigation which might address problems like that. But what it actually is in each case, we can't solve all the problems of the existing air quality here. What we have to deal with is how do you address new applications coming forward, and that's what this policy is about, rather than this isn't about the plan strategy. You may disagree with the effectiveness of the strategy and so on, but we have to deal today with this policy, Mr. Chairman.
Well, I was just going to echo that. I think our main difference is I don't think you're that keen on mitigation, certainly with regard to public transport. But we have to positively prepare plans. So we have to be positive about issues, stroke problems. We have to try and solve the problems rather than describe them.
So I was not saying that buses aren't suitable. What I'm trying to say is I'm not sure that mitigation measures that we currently have will be sufficient to meet that MPPF and will come from government as a consequence of the High Court ruling. We need more in the future. That's all I wanted to say.
Okay. Well, fine, yes. And this possibly may be one of the ways to deal with it. But I just think that I don't think the policy is very well expressed or very clear, and this kind of hierarchy that you need to go through according to the scale and location of development. And I think I'd urge the council just to redraft it, and maybe to actually just kind of turn it round. So you kind of start with the smaller developments, and then you kind of work up to the ones which need have the biggest impact on the air quality exceedance areas and need the biggest response, essentially, and so that people can read this and they can understand where they fit into the kind of pyramid. Ms. Wedgton.
Thank you, sir. I'm grateful for your comments in that regard, and I would concur that we do need to relook at this policy. I think one of the first things I've considered is in criterion 2 the fact that there is reference to an emissions statement. Well, normally I have to say that an emissions statement is produced by governments or specialist agencies at a much larger scale than local authority scale, and what we would normally accept for specific development proposals is an air quality impact assessment. Taking that on board, I think there is potential. I think Mr. Buckley's comments are interesting as well regarding the merger of 2 and 3. The initial starter for 10, which we'll come back to you with, are proposals within or affecting. I think affecting is, does help us in that regard. Air quality management areas that are likely to have a negative impact on air quality or of a sufficient scale to impact on local communities in this regard should identify sources of emissions to air from the development and identify proportionate measures per MPPG how these emissions will be minimised and mitigated. And I think that should suffice in dealing with the issue of 2 and 3, given that really they're both dealing with similar matters and we wouldn't require an emissions statement in those circumstances. Thank you.
Just Driver.
Just very briefly to echo Mr. Buckley's comments, which were in fact the concerns that Headcorn Parish Council raised in its Regulation 19 response, that a lack of joined-up thinking between this policy and the spatial strategy could potentially cause problems, and to make you aware of the document ED 043 brackets B, which I picked up from the website last night. Now, I'm not a transport engineer, and I can't profess to having read it in any particular detail, but my skim reading of this document suggests that the problems associated with the A229 and the A274 will be extremely hard to mitigate in terms of improving traffic flows along those roads. And of course, that's with existing traffic flows before you add in traffic not just from villages such as Headcorn and Staplehurst, but also developments in Langley. So I think it is important that the strategy is joined up.
Yeah, of course, we'll be considering transport again tomorrow. Okay. Right. I think I suggest we have our break now. Yep, okay, and then we'll come back to GM6. So we'll just take 10 minutes, well, just, if we just resume at 5 to 12, because we haven't got very far through the agenda as yet, so take a break.